paid my dues time after time. I've done my sentence, but committed no crime.
Hello, everyone. It's Nate Vid 2. I'm going to go into the Constitution, and as you can see, this is from ushistory.org, linked in the text on Substack. Okay, let's begin. The Constitution of the United States. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for a common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our prosperity, do ordain and establish this Constitution for the United States of America. This is annotation. The preamble of the Constitution is a statement of inspiring promise to Americans about the things that the new federal government intended to achieve for we, the people of the United States. Some of the specific objects of government stated in the preamble: the establishment of justice, ensuring the operation of society, ensuring a peaceful operation of society, and providing for common defense have long been understood to be the primary responsibility of any government. The promise to promote the general welfare, excuse me, general welfare and to secure the blessings of liberty are more open-ended suggestions that the government's responsibility extended not merely to provide essential services, but also to benevolent oversight of the polity. Although the words of the preamble do not carry any the force of the law, they have had substantial power over the life of the Constitution. Article 1, Section 1. And you can see it's very short. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of the Senate and House of Representatives. Annotation: it is no accident that the first article of the Constitution deals with the structure of the power of Congress. For virtually all of those who took part in the drafting of the Constitution considered the legislative branch to be the most important and rightfully the most powerful of the three branches of government. There was a broad agreement among framers of the Constitution that the Congress should consist of bicameral legislative, and the House of Representatives, the lower house, was conceived to be the great repository of the people of the nation at large, while the Senate, the upper house, was to be comprised of only those knowledgeable, well-educated, victorious, who would be relied could be relied upon to act a moderate influence on the whims of the people at large. Section 2. The House of Representatives shall be comprised of members chosen every year by the people of the several states, and electors in each state shall have qualification requisites for the electors of the most numerous branches of the legislature. No person shall be representative who shall not have attained the age of 25 years and have been 7 years a citizen of the United States, who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Okay, and this right here is an amendment adjustment. You can scroll down to the bottom and see which one it is. Representatives in direct tax shall be apportioned among several states, which may be included within the union according to their respective numbers, which shall determine by adding the whole number of free persons, including those bound to the service for a term of years, and exclude Indians not taxed, three-fifths of all persons, all of persons. Ooh, okay. Representatives and direct tax shall be portions, several states. Well, this has already been updated. Okay. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States and within every subsequent term of 10 years in the such manner as they shall be law direct. The number of representatives shall not exceed one for every 30,000, one for every 30,000, but each state shall have at least one representative, or until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, Georgia 3. And that's all that right there. Okay. When vacancies happen, when vacancies happen in the representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies. The House of Representatives shall choose their speaker and other officers and shall have the sole power of the impeachment. Okay. And here's a notation. The framers of the Constitution stipulated that members of the House of Representatives, the people of that people's house, shall serve relative short terms of only 2 years, after which they would be required to seek re-election should they wish to continue to represent their state. The delegates could not agree on who should be allowed to vote for the members of the House of Representatives, so they left the matter of voting requirements up to the state legislators, which had up to that time set qualifications for voters in each of the states. In 1787, the states accepted New Jersey, which briefly permitted females to vote, limited the franchise to free men, a term usually interpreted to exclude free blacks, and most it required that voters on at least some of the property by the 1820s. Most states had opened the franchise to free white males, regardless of whether they are owned property. Subsequently amended the 15th prohibits the denial of the franchise on account of race, color, or previous condition of servitude. The 19th enhanced women, and the 26th establishing a uniform voting age of 18, served to create a common nation standard for voting in the federal elections. The requirement that members of the House of Representatives reside in the state in which they have chosen reflect the brief belief that representatives, if they are to serve people who elect them, they must have close and meaningful ties to the communities in which those people live. The three-fifths of all of the persons, refers to the in the section in is the result of an infamous three-fifths compromise in which slaves, through not mentioned by name, were to be counted as three-fifths of a person in apportionment of representation in the House of Representatives, as well as in the apportioning of the amount of direct taxes to be paid by each state. Three-fifths ratio. It was purely arbitrary. It was consequence of a fundamental contradiction that the convention delegates were unable to resolve. Slaves were human beings, but by law of most states, they were also regarded as property. The passage of the 20th or 13th Amendment abolishes slavery or rendering this portion of Article 1, Section 2 null and void. Although the original Constitution laid down formula for representation based on population and three-fifths of the other persons, none of the delegates to the 1787 convention really knew what the actual population of each state was. The initial apportionment of representation was merely a guess, but the Constitution did provide for a census of the population to be taken every 10 years, a practice that began in 1790 and has continued until present day. The sole power of impeachment refers to the first step, equivalent to an indictment or bringing to trial. In the first step, bringing of to trial. In the removal of federal officials, the grounds for impeachment set forth in Article 2, Section 4, treason, bribery, and other high crimes and misdemeanors have been subject to widely varying interpretations. That's all that. Okay, where's Section 3? Starting Section 3, I will read from, actually, the book I'm getting this reading from is The Penguin Guide of the United States Constitution by Richard Beeman. And it's annotated, so it gives a little foreshadowing and stuff. The Senate of the United States shall be comprised of 2 senators from each state, chosen by the legislature thereof for 6 years. Each senator shall have 1 vote. Immediately after, they shall be assembled in the consequence of the first election. Assembled in consequence of the first election, they shall be divided as equally as may be into 3 classes. The seats of the Senate of the first class shall be vacated and expire of the second year. The second class of the expiration of the second year of the second class, the expiration of the 4th year, and the third class at the expiration of the 6th year, so that 1/3 may be chosen every second year, and if vacancies happen by resignation or otherwise during the recess, the legislator of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such a vacancy. Okay, no person shall be a senator shall have attained the age of 30 years and been in 9 years of citizenship in the United States, and who shall not when elected, be an inhabitant of the state, that state for which he shall be chosen. The President of the United States shall be the President of the Senate, but shall have no vote unless they be equally divided. Basically, if they end up in a tie, it's what it says. The Senate shall choose their other officers and also a president pro tempore in the absence of the vice president, and when he shall exercise the office of president of the United States. The Senate shall have the sole power to try all impeachments when sitting for that purpose. They shall be on oath of affirmation when the president of the United States is tried. The Chief Justice shall preside, and no person shall be convicted without concurrence of 2/3 of the members present. The judgment in cases of impeachment shall not extend further than removal from office and disqualify them to hold and enjoy the offices of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. Annotation. The Senate, as the upper house, was conceived as a more deliberative body whose members would be comprised of the most virtuous and knowledgeable citizens in the land. The framers of the Constitution believed that the senators should therefore serve long terms in order that they might be better insulated from the immediate pressures of the public opinion. One of the means by which senators would be protected from the popular whims was to provide for an indirect method for their election, with the legislators of the individual states being given the power of such elections. The provision for staggered terms of service was designed to prevent sudden convulsive turnover in the members of the Senate, consistent with the views of the members of the Senate were expected to possess superior knowledge and experience. That the minimum age of senators was set at 30. The length of time before becoming a citizen of 9 years, as opposed to 25 years of age and 7-year citizenship for a member of the House of Representatives. The framers of the Constitution were aware of the necessity to provide for the vice president who would assume the president's duties in the event of his death, disability, removal, but they had a hard time thinking of any function the vice president might perform. The provision of Article 1, Section 2 designated the vice president as the presiding officer over the Senate. Is the only item in the Constitution that speaks of the limited official duties of the vice president. The Senate, as the more deliberative of the two legislative bodies, was given the responsibility of trying impeachment cases seeking to reinforce the principled separation of powers. The Constitution designates the Chief Justice, the U.S. Supreme Court, as the person who would preside over the impeachment of the president. Section 4. The times and place and manner of holding elections for the senators and representatives shall be prescribed in each state by legislator thereof, but Congress may at any time by law make or alter such regulations except as to place of choosing senators. The Congress shall assemble at least 1 year once every year, and such meetings shall be on the first Monday in December unless they shall by law appoint a different day. Okay, annotation, as was the case in as was the case in the instance of voting requirements, the framers of the Constitution were content to leave the matter of when congressional elections should be held to the state governments. The stipulation that Congress should assemble on the first Monday of December was altered by the passage of the 20th Amendment in 1933. The practical effect of original term of Article 1, Section 4 was to delay the seating of new members of the Congress until March, creating a period of months during which a lame duck Congress would be in session. Improvements in the transportation and communication made it possible and desirable to move this stipulated time of the meeting of Congress to January 3rd. Section 5. Okay, Section 5 is each house shall be the judge of the elections, returns, and qualifications of its own members, and a majority of each shall constitute a quorum to do business, but a smaller number may adjourn from day to day and may be authorized to compel the attendance of the absent members in such a manner and under such penalties as the House may provide. Each House may determine the rules of its proceedings, punish its members for disorderly behavior, and with concurrence of 2/3 expel members. Each House shall keep a journal of its proceedings and from time to time publish the same, excepting such parts as many in judgment require secrecy, and the yeas and nays of the members of either house on any question shall, at the desire of 1/5 of the house of those present, be entered into on the journal. Neither the House during the session of Congress shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than that of which two houses shall be sitting. Annotation. The item in Article 1, Section 5, giving each branch of the legislative control over their own proceedings reflects a long-standing desire dating back to the gradual evolution of the English Parliament as the legislative body with powers independent of those of the king to preserve the independence of the legislator from executive encroachment. The section of this Constitution shall encourage. Constitution also encourages openness in the publication and dissemination of the proceedings of Congress. And that's in the official record, which is published on congress.gov. You can look it up there. I've also been posting some of them into my Substack, so you can look there if you want to see what they look like. Section 6. The senator and representatives shall receive a compensation for their services to be ascertained by law and paid out of the Treasury of the United States. They shall, in all cases except treason, felony, a breach of the peace, be privileged from arrest during the attendance at the Senate attendance at the session of their respective houses, and in going to and returning from the same. And for any speech and debate in either house, they shall not be questioned in any other place. No senator shall, during a time for which he was elected, be appointed to any other civil office under the authority of the United States, which shall have been created, or emoluments whereof shall have been increasing during such times, and no persons holding any office under the United States shall be a member of either house during the continuance in office. Annotation. The provisions for paying salaries members of Congress have provoked some disagreement among the delegates, as at least some members of the Continental Convention thought that the public servant should be virtuous and wealthy, gentlemen capable of serving office without the need to seek compensation. The provision provided immunity for arrest except in cases of treason, bribery, and a breach of peace, was another attempt to ensure the independence of the members and of the legislature. The provision prohibits services in other public office while serving in Congress, marked rejection of practices in English Parliament, where members of Parliament also served as ministers in the King's Cabinet. More generally, it is reflected a desire to reinforce the principles of the separation of powers. Section 7. All bills for raising revenue originating in the House of Representatives, but the Senate may propose concurrent amendments as in other bills. Every bill which shall have passed the House of Representatives and the Senate before it becomes law, be presented to the President of the United States. If he approves, he shall sign it. But if not, he shall return it with his objections to the House in which it shall have originated, who shall enter the objection at large on their journal and proceed to reconsider it. If after such reconsideration 2/3 of the House shall agree to pass the bill, it shall be sent together with the objections to the other House, and by which it shall likewise be considered sent together with the objections of the other House, by which shall likewise be reconsidered, and if approved by 2/3 of that House, shall become law. But in all such cases, the votes of both houses shall determine by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each house respectively. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be law in the like manner as if he had signed it, unless Congress by adjournment prevent its return, in which case shall not be law. Every order, resolution, or vote which the concurrence of the Senate and the House of Representatives may be necessary, except on questions of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 in the House and the Senate of Representatives. To the rules of limitations prescribed in case of a bill, the power of annotation, the power over the purse has considered the most important of the powers of the government, of any government goodwill. Indeed, it was the British Parliament attempt to tax the colonies without their consent that precipitated the American Revolution. The decision to give the federal government the power to levy taxes, a power denied to the government under Articles of Confederation, may well have been the most important one made by the delegates of the convention. It's trustworthy. It's noteworthy, however, that they gave the people's body of the House of Representatives the power to originate revenue bills. The next lengthy portion of Article 1, Section 7 is one of the hallmarks of the system of separation of powers by checks and balances. It spells the process out this process by which the legislative proposal must be passed both House and Congress, then receive the assent of the president before it can become law, provided for a limited executive veto over congressional legislative, but gives to the Congress the power, if it can muster 2/3, to override the presidential veto. Section 8. The Congress shall have the power to lay, collect taxes, duties, imposed and exercise, to pay debt, and provide for common defense, the general welfare of the United States, but all duties imposed and exercises shall be uniform throughout the United States. To borrow money on the credit of the United States, to regulate commerce with foreign nations and among several states and with Indian tribes, to establish an uniform rule of naturalization and uniform laws on the subject of bankruptcy throughout the United States. The coin money, regulate the value thereof and of for foreign coin, and fix the standard of weights and measurements, to provide the punishment of counterfeiting the security and current coin of the United States, to establish a post office and post roads, to promote the progress of science and all useful arts by securing for limited times to authors and inventors the exclusive right to their respective writing discoveries, to constitute tribunals inferior to the Supreme Court, to define and punish piracy felonies committed on the high seas and offenses against the law of nations, to declare war, grant letters of marque and proviso, and make rules governing capture of land and water, to raise and support armies, but no appropriations of money that to that use shall be for a longer than 2-year term, to provide and maintain a navy, to make rules for government regulation and land and naval forces, to provide for call forth the militia, to execute the laws of the nation, suppress insurrection and repel invasion, to provide for organizations, to provide for organizing and arming and disciplining the militia, and for governing such part of them as may be employed in the services of the United States, reserving to the states respectively appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. The exercise exclusion legislative in all cases whatsoever over such districts not exceeding 10 miles square, as may by concession of particular states and the acceptance of Congress, become the seat of the government of the United States, and to exercise the authority over places purchased by the consent of the legislator of the state in which the same shall be for erecting of forts, magazines, arsenals, docks, yards, and other needful buildings, and to make all laws which shall be necessary proper for carrying out the execution of foregoing powers and all of the other powers vested by the Constitution in government of the United States or in the Department of Officers thereof. Notation. Many Americans think the Constitution is a document that protects the liberties of American citizens by defining those things that the federal government cannot do. This is the central concern of the first 10 amendments to the Constitution, which today we call the Bill of Rights. But in fact, in many respects, Article 1, Section 8 constitutes the heart of the soul of the Constitution. It specifically enumerates the powers of the federal government is limited to exercise. The initial version of this article, as outlined in Virginia Plan, gave an open-ended grant of power to the Congress, simply providing that Congress would have the power to legislate in all cases to which the separate states are incompetent, but when the Committee of Detail produces a comprehensive first draft of the Constitution in early August 1787, the general grant of power was replaced by the more specific enumeration of powers that appear in Article 1, Section 8. Among the most important powers enumerated in Article 1, Section 8 are, as previously mentioned, the power to levy taxes, the ability for the government to provide for itself permanent revenue with which to finance its operations. It was the simplest, most important power given to the new federal government. The broad purpose for which that power granted to provide for common defense and general welfare of the United States have been interpreted in widely different ways over the course of the nation's history, with the general trend leading towards an expansion of activity financed by the federal taxation power. 2, the commerce power has proven to be one of the most important and far-reaching provisions of the federal Constitution, utilizing an over-expanded definition of the power regulating commerce among the several states. The federal government has broadened the definition of commerce to include not only the shipment of goods across the state lines, but also many of the forms of activities, the building of the interstate roads, the power to legislate or the power to regulate the business activities of corporations and the pass to environmental legislative, and the power to pass environmental legislation, consumer protection laws, and occupy safety regulations. Establishing post offices and post roads seems mundane enterprise, but this provision of the Constitution, in conjunction with an expansive view of Congress's role in promoting the general welfare and regulation of commerce, marked the beginning of the creation of the national infrastructure that would tie 13 previously independent sovereign states into a single nation. The clause relating to the promotion of science and useful arts gives Congress the power to enact patent and copyright laws. 5, 16, or Clause 10 through 16, Article 1, Section 8 deal with the war powers of Congress. If the power over the purse has long been considered to be the most important governing government's powers, the power over the sword, the ability not only to declare war, but also to vote appropriations for the financial support of the war, runs close second. Congress's power to declare war overlaps the power of the president as commander-in-chief of the nation armed forces to direct the actual conduct of the war. In one sense, the overlap is part of the Constitution's system of separation of powers, but in another, it has become a significant source of constitutional controversy in recent years. In numerous cases, such as the mid-20th century in the Korean War, the Vietnam War, and the First Gulf War, and most recently the wars of Iraq and Afghanistan, the president had proceeded with the prosecution of the war without formal congressional declaration, and that is wrong. The first Gulf War with late invasion was put in place just before the first attack. I'll have to look those up because I'm not sure that that's true. 6, Congress power. Congress' power over the appropriation. The money gives it a substantial say over how or whether the war should be fought, but it has only rarely denied funds for support of any army or navy once the war is underway. 7, the 17th clause gives Congress the power to exercise exclusive legislation over such districts as may become the seat of the government, is the basis on which Congress created the District of Columbia, which is regarded not as a state, but as a federal territory in the nation's capital. The final provision, Article 1, or 8, the final provision, Article 1, Section 8, has proven to be one of the most important and controversial provisions of the Constitution by giving Congress the power to make all laws necessary and proper for carrying into effect the previous enumerated powers. The framers of the Constitution opened the door to significant expansion of federal powers when, in just a few years, adoption of the Constitution, some of the most important figures of the Revolutionary era found themselves in bitter disagreement on meaning of the phrase necessary power, with President Washington's Secretary of the Treasury, Alexander Hamilton, arguing for a broader construction of its meaning. For example, as needful, useful, and conductive. 2. And Thomas Jefferson and James Madison argued for a strict construction, for example, as absolutely necessary. This line, constitutional differences between broad constructions and strict constructions, was a bitter source of contention in the period leading up to the Civil War and continues in somewhat dismissed forms between the respective proponents of the more limited, more active federal government even today. Section 9, the migration or importance of such persons as any of the states now exist shall think proper and to admit shall not be prohibited by Congress prior to the year 1808, but tax or duty may be imposed on such, importations not to exceed $10 for each person. I wish we could still do that. The privilege of the writ of habeas corpus shall not be suspended unless in the case of rebellion, invasion, the public safety may require it. And that's why he kept saying invasion, rebellion. We're trying to start a rebellion. That's what he's trying to do. That's why he's using those words. No bill of attainder, or ex post facto law shall be passed. No capitation or other direct tax law shall be laid unless in proportion with the census enumeration herein before the direct to be taken. No tax or duty shall be laid on articles of export from any state. No preference shall be given by any regulation of commerce or revenue to ports of one state over those of another state, nor shall vessels bound to or from one state be obliged to enter and clear or pay duties in another. No money shall be drawn from the treasury, but in consequences of appropriations made by law and a regulated regular statement of an account of the receipts and expenditures of all public money shall be published from time to time. No title of nobility shall be granted by the United States, and no person holding the office of profit or trust under them shall, without consent of Congress, accept any presents, emoluments, office, or title of any kind whatsoever from any king, prince, or sovereign state. That is funny because that would be a violation. The plane would be a violation by that. Okay. That's Article 9 has been. Yeah, Article 9 has been read. Okay, we're almost done. And Article 9, here's notations. Article 1, Section 9 outlines those actions that the federal government may not take. The most controversial of these prohibitions is contained in the very first item of the convention. Delegates from South Carolina and Georgia, whose slaves' economies were still expanding, insisted that no legislation interfere with the African slaves trade be permitted unless at least 20 years after the adoption of the Constitution, the prohibition of any legislative effect to the migration of import or importation of such persons as any of the states now existing shall think proper to admit, was intended to ensure the protections, as in all instances in which the Constitution deals with the institution of slavery, neither word slave or slavery is explicitly mentioned in the text of the document. In 1808, the U.S. Congress enacted a legislation abolishing the international slave trade, but during that 20-year interval, some 200,000 slaves were imported from Africa to the United States. Many of the most important prohibitions to the federal government action laid out in Article 1, Section 9 are designed to protect the fundamental liberties handed down to the American through English common law. Perhaps the most important of these was the privilege of habeas corpus, the right of a prisoner to challenge his imprisonment in a court of law. On at least a few occasions, American presidents have suspended this privilege while either suppressing rebellion or protecting the public safety. During the Civil War, President Abraham Lincoln held disloyal persons suspected of giving aid and comfort to the Confederate was caused in prison without benefit of trial. More recently, President George W. Bush cited the provision of the Patriot Act, as well as implying executive power, sanctioned the holding of several hundred enemy combatants in the war on terror, the prohibition against the bills of attainder, the issuing of edicts aimed at punishing individuals or groups of individuals without benefit of trial, and the ban of ex post facto law, criminal laws aimed at punishing individuals for actions taken before the law itself was passed, were also rooted in the tradition of the English Commonwealth. The prohibition of taxes on exports was purely a political bargain between northern and southern states, and was designed to protect the interests of the South, whose agriculture exports formed an important part of its economy. The prohibition against direct taxes unless such taxes are levied precisely in proportion to the number of citizens in each of the states shall another attempt to protect the institution of slavery from being taxed without existence. This provision was subsequently changed by the passage of the 16th Amendment, making possible the imposition of federal income tax. While it was unthinkable today for our federal government to grant title of nobility to any citizen, the provision in Article 1, Section 9 prohibits granting titles of nobility and placing additional restrictions on the receiving president's emolument, office, or title. For foreign state, reflected the strong commitment of the framers of the Constitution that their government should be a Republican one and not that reflected the aristocrats' ways of Europe. That Republican does not mean the party Republican. The Republican there means Republican, the Republic. It's a republic. That's what they're calling the Republicans, the whole republic at that point. Section 10, no state shall enter into treaty, alliance, or confederation, grant letters of marque or reprisal, coin money, emit bills of credit, make anything but gold or silver, coin tender in payment of debt, passed by any bill of a tender, post facto law, or law impairing obligation of contracts, or grant any title of nobility. No state shall, without the consent of the Congress, lay any impost or duties on imports or exports except what may be absolutely necessary for executing its inspection laws, and the net produce of all duties imposed laid by the Treasury of the United States, and all such laws shall be subject to revision and control by Congress. No state shall, without the consent of Congress, lay any duty or tonnage, keep troops or ships of war in time of peace, enter into an agreement or compact with any other state or with a foreign power, or engage in war unless actually invaded, or in such imminent danger as will not admit of delay. And notation. The provision in Article 1, Section 10 stipulate those things that our state governments are prohibited from doing. The most important of these are, number one, individual states may not enter into separate treaties with foreign nations. Number two, the governments of the states are bound by the same requirement as the federal government in the prohibition of bills of attainder, ex post facto laws, and impairing obligations of the contracts and granting titles of nobility. State governments may not issue currency for the purpose of paying debt unless that currency is in gold or silver. This provision, in reaction to laxness of some states' governments that issued depreciated or in some cases worthless currency during the period of the Revolution, this provision marked but only the beginning of the creation of a single national currency. During the period of the Confederation, many states eager to raise their own revenues levied tariffs on goods entering their ports from other states. The new Constitution reserved the power of taxation imports to the federal government alone, preventing states from enacting their own tariffs. 5. Although the individual states were permitted to maintain their own militia for maintenance of order within the boundaries, the Constitution prohibits states from maintaining either a standing army or navy in time of peace. It also prohibits the states from entering into an agreement with any other state's foreign power for military purposes. And that's Article 1. The basic meaning of an ex post facto law means a law that was passed, they can't use it for previous needs. Basically what it comes down to. Thank you for being here and listening to the whole video. And please like, share, follow me on my Substack and all of my other social medias. And remember, you are loved no matter what you do. Thank you and goodbye.